Let us discuss the next question. This is a question from 2021. What was the exact constitutional status of India on 26 January 1950? So this question is asking about the constitutional status of India on the day of adoption of the constitution. A democratic republic, a sovereign democratic republic, a sovereign secular democratic republic, a sovereign socialist secular democratic republic. Now this question is also linked to the amendment of the preamble. Now if you go to the text of the preamble, it says that we, the people of India, so here the people of India, and ultimately when we say that we adopt and give to ourselves this constitution, it shows that the people of India are the source of the power, and having solemnly resolved to constitute India into a sovereign socialist secular democratic republic. So this is the nature or characteristics of the Indian state. What was India? What is India currently? So this is it. And the justice, liberty, equality, fraternity, all these are the objectives which are to be achieved. So the question is asking not what was there in the current day, but what was there on the day of adoption. So we have to look at the original preamble. And let us briefly recall the provisions of the preamble. It is the brief introductory statement of our constitution. It is the philosophy behind the constitution, and it gives a key into the minds of the constitutional makers. It tells us what the constitutional makers aspired for India, what they wanted for India as a country. And it is based on the objectives resolution which were drafted by the Jawaharlal Nehru. And we had only one amendment to the preamble till now, that is the 42nd amendment in 1976. The words socialist, secular and integrity were added. So here the word socialist, secular and here the integrity were added to the preamble. So if you remove this, what is there? We will have sovereign democratic republic. So that is why in the statement which says that the sovereign democratic republic, that is B, is the correct answer, because on that day India was just a sovereign democratic republic. Later during the amendment we added the words socialist, secular and the integrity. And preamble is neither a source of power to the legislature nor it is a prohibition to the power of legislature, and you cannot go to a court saying that the government has violated the preamble. You cannot go to a court and justify the things that are given in the preamble, and it is not enforceable in a court of law. But if there are ambiguous provisions in the constitution, the court will take the help of the preamble in order to come up with a harmonious reconstruction. So coming back to the question, the answer is sovereign democratic republic, because the other two words were added later on during the amendment. We were discussing the questions from polity. Let us discuss the next question. This question is from 2020. The preamble of the Constitution of India is A, part of the Constitution but has no legal effect. B, not a part of the Constitution and has no legal effect either. C, a part of the Constitution and has the same legal effect as are any other part. Option D, a part of the Constitution but has no legal effect independently of the other parts. Now this is about the preamble. So preamble is a brief introductory statement for the Constitution. It reflects the aspirations of the people and it has the philosophy of the Constitution within it. And it was based on the objective resolutions which was drafted by Jawaharlal Nehru. And preamble was amended only one time, that is the 42nd amendment of 1976, where three new words, the socialist, secular were added and integrity was also added. The preamble is neither a source of legislative power nor it places any prohibitions on the power of the legislator. Because of that, it is not justifiable and non-enforceable in a court of law. So ultimately, when the preamble says that it begins with we the people, it shows that the concept of popular sovereignty. Now there have been few landmark cases with regard to the preamble. What are those? In the very first Berubari case, the Supreme Court has said that the preamble is not a part of the constitution. The court said that the preamble shows the purpose behind the provisions of the constitution, and if the terms of the constitution are ambiguous, if the provisions are ambiguous, we can take the help of the preamble in order to understand the overall philosophy, the overall objectives of the constitution. But the court said the preamble is not a part of the constitution. Now, because if it is a part of the constitution, it also cannot be amendment, because you cannot amend something which is not a part of the constitution. So because of that, as a corollary, the court said you cannot also amend the preamble in the Berubari case. Later on in the Keshwananda Bharati case, where the basic structure and doctrine came into force, the court said the preamble is a part of the constitution and it reversed its earlier judgment of the Berubari case. And the court also said, now because the preamble is part of the constitution, it can be amended, but subject to the basic structure of the constitution. And finally, once again in 1995, in the LIC of India case, the court reiterated its earlier judgment in the Keshwananda Bharati case and told that the preamble is an integral part of the constitution. So the preamble is part of the constitution, but it is not justiciable and not enforceable. And if there are any ambiguous provisions in the constitution, the help of the preamble could be taken. So if you see here, the first statement says that it is part but has no legal effect. The second one says not a part of the constitution and no legal effect. The third statement says part of the constitution and has the same legal effect. So ultimately in the option D, it says that part of the constitution but has no legal effect independently of the other parts. So the preamble, if it is read wholly on the constitution, then it has the ability to overcome the ambiguity. So option D is the correct answer for this question.